All right. I believe everyone is on now. Am I correct, Marissa, that we have everybody on? Thank you. We are now here in the matter of Commerce Bank versus Robert McGowan. Commerce Bank is represented by Michael Mather and Thomas Cahill, and Mr. McGowan is represented by Stephen Wandro. We'll do a quick sound check. Mr. Mather, would you please respond so I know you can hear me and I can hear you?
Yes, good afternoon. I can hear you. Can you hear me?
Thank you. Yes, thank you. And I'll ask the same of Mr. Cahill. Can't hear you, but I saw your mouth moving. There you go.
I can hear you.
Okay, thank you. And it's my understanding you are local counsel. So I believe, are you both going to be arguing or just Mr. Mather?
Just Mr. Mather.
Okay, thank you. And then Mr. Wandro, can you hear me? And I'd like to hear you.
I can hear you,
Thank
Justice.
you.
Yes.
Thank you. And Mr. Wandro, you are the appellant, so you may begin.
Thank you. May it please the court and counsel. Well, the question, getting down to the nub of it all, is whether the deferred comp plan that's the subject of this litigation is exempt under 627.6 sub 8 sub E. And the procedural history is pretty straightforward, I guess, for a collection case. Commerce Bank obtained a judgment against Mr. McGowan in Minnesota in 2015. That judgment was patriated to Iowa sometime thereafter. The bank then began collection actions. One of the actions was a garnishment of Mr. McGowan's wages. Now, within that garnishment, he was also receiving payments under his deferred comp program. And so as a response, we, in representing Mr. McGowan, asked the court or interceded and asserted the exemption statute, saying no, you can't touch the touch the deferred comp because it's exempt. We had a hearing before the district court. The district court ruled against us and said that the plan did not qualify for exemption status. We feel strongly that the district court erred in doing so, and so we are here now to advance our arguments. The plan that's in front of you, in our opinion, is a rather straightforward deferred comp plan. There are two plan benefits. One is vested immediately, and that is a plan where the contribution approximately realizes the value of the works in progress as well as the receivables. And then the second element is a pro rata portion of the intangible value of the professional practice. Under paragraph 4.1 of the plan, there are triggering events. They're set forth there: separation from services. The participant reaches the age of 65 years old. There's disability, there's death, there's sale, and then the sale of the business. We contend that actually that benefit plan is a pension under the statute in question. I think it's helpful perhaps to look at some of the history of what was going on with some of the cases that the district court was looking at in order to find out where this pension plan fits within the statute. Now, one of the big cases that both the bank and we cite is the Ibert cases, which gives a really, really good history of how all of these issues kind of came to be. And most of them started with this whole notion of an annuity. Now, when you look at the statute, an annuity is part of the protected plans. And so what was happening in effect was very clever debtors attorneys were taking tens and if not hundreds of thousands of dollars of monies that were otherwise available to creditors and putting them in annuities. And when the first courts were looking at this issue, and they're mostly bankruptcy courts, what they found was, yes, these are annuities, but what it came down to, as far as what the courts were doing, they essentially had two options. One was the triggering, and that is the age going to trigger the exemption, or is it going to be based on the age of the person receiving the funds? And so what was happening early on is debtors were receiving hundreds of thousands of dollars of monies based on the fact that they were in retirement age. Well, this got to the point where the court had to revisit it. And the way it revisited it was to start taking a look at what are the characteristics of a pension. And even though we have the word pension and annuity, do we really mean that an annuity is to be used as this vehicle to essentially swallow the exemption statute by allowing all of this money to be beyond the reach of creditors? And so the characteristics of the pension started to be examined by the courts, especially the Huebner court and the Eibert court. And in our brief, we kind of talk about the annuity line of cases and then the deferred comp profit sharing kind of cases. But in both cases, I think what the court was doing was trying to find out what are the characteristics of a pension and how do we fit the particular plan in the statute by looking at those characteristics.
Mr. Wandro, and this
Yes.
is Justice McDonald. In that regard, can you talk a little bit about Rousey versus Jackaway and how that applies to the facts and circumstances of this case?
Judge, I don't know if I'm tracking on the exact name of the case.
Sorry, Rousey is the U.S. Supreme Court case that deals with definition of other similar plan within the parallel federal exemption under 522D.
I can't really speak to that. I can only tell you that I know that there was this tension between 522 and state exemption statutes. And I know that at some point, the Supreme Court ruled that you can look to the state statutes. In fact, under 522, the states have the ability to either use 522 or to use the state statutes. And that's exactly what Iowa has done. It has chosen the state statutes. But with that being said, there's a lot of parallel between 522F and the statutes that the pension statutes that you see in Iowa, and that are also very similar to statutes in other states such as Missouri and Minnesota, which are mentioned in the Pettit case, which we think is the case that the court should be looking at. So that's all I can tell you about that. But I'm confident that we can use the state statutes here, and we can look to the federal statutes for some guidance. But I think Iowa has established a very clear path now of jurisprudence of trying to deal with this issue.
Mr. Wandro, this is Ed Mansfield. Looking at the facts of this case, the impression I get is that what Mr. McGowan is getting is kind of a buyout of his interest in this business, sort of a buyout of his share of that business. And do you have any law or precedent or anything you can cite to me where sort of a buyout is treated as a pension annuity or similar plan under either the Iowa exemptions or the federal exemptions?
I don't have a case on point, but I can tell you at the end of the day, it's all money, because either Mr. McGowan would have received those buyout, he would have been entitled to something. Okay. And this whole plan is a deferred compensation. So what's happening is he didn't receive it during the time of his employment. Once he reaches age 67, he is going to receive it. And that's what was garnished. So I think the focus needs to be not on why. I think it needs to be focused on the fact that it's deferred comp. It was the payments were deferred over a long period of time. In this case, you didn't have full vesting on the type 2s for 20 years. And this was a plan that's been in effect since 1993 with this organization. It's a plan that's it's designed to help the employee. And the other elements too, which Pettit and in fact Albert talk about, is access to these monies. There were substantial impediments to Mr. McGowan getting these monies. Now, unfortunately, or fortunately, the district court in this case found that that factor was met, that there were enough impediments that Mr. McGowan did not have unfettered access to these monies, which would have lent to the conclusion that this really is more like an annuity and therefore should not be exempt.
Mr. Wandro, can you answer a couple of questions for
Sure.
me about the mechanics of the plan?
Sure.
As I understand it, this is not a deferred comp plan in the sense that these are specific wages earned by Mr. McGowan that are set aside for payment later, like you would have under. These are two types of deferred compensation, and one relates to the value of the whips, and the second type relates, maybe it's an oversimplification, and correct me if I'm misstating, some sort of percentage value of the goodwill of the business, essentially, is how I understood it. But in any event, it's not deferred salary or deferred wages. It's based on something other than that. Is that correct?
That's correct.
Okay.
But my response to that is this, is there's nothing, well, number one is both Albert and the cases that have followed from it all talk about the fact that you're not going to have a one size fits all, that these factors, you have to take a very, very close look at the facts of each case. What makes this case, and you've asked a very good question, because I think it was a question that perplexed the district court judge. This is a plan of owners. Okay, this isn't the typical plan where you have a subordinate, for example, a staff member who is an employee, and there's a match and that there are wages. This is owners, and what owners do is they do things differently than staff members. They're all contributing to the welfare of the company. They're all working towards it. And again, at the end of the day, it's money and it's deferred. He could have received that dividend. He could have received whatever you want to call it during the time of his employment before he reached age 67, but he chose not to. And so that's what's being deferred. And I think it does, when you take a look at the nature of what the courts are saying, when you take a look, I think it qualifies on all fours with what a pension is. And again, it's the deferral, and that is taking the wages you could have earned and getting them later in life when you need them, and
Counsel,
when you're not
that,
making some.
On that point, or to follow up on that point, there's the allegation here that these are just sort of paper balances, that it's not like an IRA or maybe a typical pension where there's some account that's out there that's holding these funds. Do I have that right?
It is a paper, but the funds are identified. I mean, it's really let's take an IPERS account. I mean, I know how that works. Your people who work for the state of Iowa are deferring some of their income. There's a match from the state. And that's put on paper somewhere, and you can look at that account and know what you're getting. That's the same thing that's at work here. We have specific amounts that Mr. McGowan is getting under the type 1 and the type 2 payments. So yes, it's done on paper, but that's what owners tend to do, is that they keep track of it on paper. And he is an unsecured creditor of the corporation. So yes, there is a tally as to what he's owed and how he's to be paid.
Mr. Wandro, this is
Yes.
just actually, so how relevant is the fact that this is a deferred comp plan under a 409A plan? Anytime a deferred comp plan meets the definition and follows what's required under the Internal Revenue Code, does it meet this exemption? Is that what you're saying? It's always a pension then?
I do. I think that what you do is you look at what the courts have said are hallmarks of what a pension is. And again, it's payment over time. It's payment to a plan. It comes from an employment arrangement, which is what has happened with Mr. McGowan. Mr. McGowan can't have unfettered access to these monies, whether they're kept in account or wherever. And the fact that they're paid by the very kinds of triggering events that's set forth in the statute: death, disability. Those are the hallmarks. That's what this plan does, regardless of its tax treatment.
Mr. Wandro, what are the penalties for non-compliance with 409A for the administration of the plan? Do you know?
I don't
Have a
know.
sense?
I don't have a sense. I'm sure there are penalties. And it would be, I don't know if it's the same kind of penalties with early withdrawal of an IRA or anything like that.
Meaning it would, compliance with 409A, as I understand it on the deferred comp plan, essentially locks up the money, barring the qualifying events under 409A, which makes it more like a retirement or a pension in that sense.
Yeah, that could be, and I just don't know. And I'm sorry that I can't answer that question specifically. My focus is I guess, been on the what the courts have been saying as you know, whether these things are pensions or not.
You can wrap up before.
But I'm
you
glad
have
to know that. But I'm glad I'm glad to know that. Anyway, so when you take a look at what I've just stated, and even under the Albert factors, we feel that in this case, the pension or the account that's at stake, the plan that's at stake here, does qualify under 627.6. We think the district court was in error in finding differently, and therefore we're asking the court respectively to reverse the decision of the district court.
Thank you, Mr. Wandro. Mr. Mather. And if you want to maybe put your mic on mute, Mr. Wandro, then we'll have no sound. Thank you.
Thank you, Madam Chief Justice, Counsel, and may it please the court. My name is Mike Mather, and I represent the respondent Commerce Bank. Iowa Code Section 627.68E exempts from execution a debtor's retirement plan and other similar assets intended to fill a wage or salary void in retirement. In this case, Mr. McGowan seeks to expand that exemption to incentive payments he receives from his current employer, offered to shareholders to incentivize the growth, profitability, and long-term success of the firm. However, as the district court held, the record lacks any evidence to suggest these plans are a retirement asset, serve as a wage substitute after retirement, or otherwise act to fill a salary or wage void. To the contrary, the record demonstrates the plan is nothing more than a paper balance used by the firm to pay its current assets to its shareholders, including Mr. McGowan, who remains employed by the firm. Based on these and other factual findings, the Polk County District Court correctly rejected the appellant's exemption claim. We ask this court to affirm the district court, making the following three findings. First, this court should affirm the district court's conclusion that the decision of the Eighth Circuit Bankruptcy Appellate Panel in Albert v. Pelican provides the correct framework for analyzing 8E exemption claims, and specifically adopt its two-tiered analysis. Second, this court should affirm the district court's adoption of the Albert factors that are used when considering the first part of that test. Those factors are whether there's contributions over time, contributions by others, a return on the investment, and the control over the assets distribution by the debtor. Third, the district court should affirm the district court's conclusion that the payments Mr. McGowan receives under the plan are not exempt under Section 8E because they do not pass the first part of the Albert two-tiered analysis. The district court engaged in a thorough review of the factual record and found no evidence that these payments were intended as retirement income or otherwise act as a wage substitute or to fill a wage or earnings void after retirement. As a result, the plan is not exempt under the statute, regardless of which test the court ultimately adopts for analyzing 8E claims. Because these findings were made—
Mr. Mather, this is Justice McDonald. Can I ask you about the Albert test and how that relates to Rousey versus Jackaway? So Rousey comes out of the Eighth Circuit, and in the Eighth Circuit, they apply the Eilbert factors, and it goes up to the Supreme Court, and they spin the Eighth Circuit, and they're defining other similar plan and not following the Eilbert factors as applied by the Eighth Circuit. So how does Rousey affect our analysis in this case, if at all?
Well, the first thing to note is that the Rousey case, and like all of these cases, are interpreting the Iowa statute in the context of the federal statute and the federal exemption statute. And there are some notable differences between the two, one of which being the explicit exclusion of profit sharing and other stock incentive plans from the Iowa statute. I think that's an important notation in the difference between the two statutes that may come into play here. But the Rousey decision, in effect, while it changes the analysis to some extent, the large overarching themes remain the same. And that's the case whether we're looking at Pettit or Eilbert or Rousey. And really, it comes down to a couple core features that I don't think there's any dispute between the parties in this case. The first is that the exemption is really intended to protect retirement assets or other things that are designed to be there for you during retirement. The second that the Rousey court made note of quite explicitly was the existence of contributions by the employee or the employer. As the court noted earlier today, and as we've detailed in our briefs, there's no evidence whatsoever of any contributions made by either Mr. McGowan, the other shareholders, or the firm with respect to this case. If you look at all of the cases that have been cited by the parties in their briefing, including the Rousey decision, the distinguishing factor between assets that were deemed exempt versus assets that were deemed not exempt is the existence of those contributions. So yes, the Rousey court did ultimately tweak the explicit Eilbert factors, but at the same time, it applied them in just a different manner. And
Well,
in the brief,
why would we rely on Eilbert versus, why would we rely on Eilbert, which is an Eighth Circuit BAP case, versus a US Supreme Court case interpreting the same provision? Doesn't it seem like, I understand Rousey may do something a little bit different, but it's on the same provision, and at least with respect to the federal interpretation, isn't that controlling?
in the federal courts, I would agree, yes, that the Rousey decision and its analysis would ultimately be controlling. But again, what we're looking at is really the framework for analysis. And what Eilbert provides over the Rousey decision is a more detailed explanation of the different factors it's using. Rousey kind of takes the two tiers in reverse. So it's a adjustment of the test by looking at the on account of whether it's age or disability or illness first, which is the second part of that two-tiered test. But then it does get into what this case is really about, which is that first test. It's whether this asset even fits within the classes of exemption of assets that are exempt under this statute. So Rousey does discuss this in some detail, but the Eilbert decision provides more guidance on specific things to be looking for. The Rousey decision's analysis of this first tier is only a couple of paragraphs.
Mr. Mather, Mr. Wandro made the point, it's all just money. You have one scenario, which is you have a large company where there are formal plans set up that where people direct certain amounts of their wages into retirement, and it's a segregated fund. And then you have a smaller company like this where it isn't done expressly, but it's done implicitly. Mr. McGowan, rather than earning as much money as he could have, and similarly the other partners, rather than earning as much money as they could have, they leave money in the company to take out later on. What's really the difference if it's all money?
Well, I respectfully disagree with Mr. Wandro's characterization that it's simply all money. Again, if you look at the cases that have analyzed this exemption, there are a couple of core features that really distinguish an exempt asset from a non-exempt asset. One of which is the physical contribution of some sort of proceeds for this explicit intent of creating a retirement account. Here, while the argument was made both at the district court and this afternoon that the shareholders were deferring compensation or otherwise choosing not to take this money at a different time, there's no evidence of that actually in the plan itself. The plan itself explicitly says we'll simply create a paper balance by using a calculation based simply on the a rolling 3-year average of the firm's
But
proceeds.
Counsel, isn't that implicit? I mean, if you're an owner and you're not taking money off the table, right? It's going somewhere, right? And if they would have just taken this money, they all would have received as owners some portion more. Isn't that right?
Well, I think it's missing some of the nuance of the plan, and one of which is that current shareholders are not active participants in the plan. So if you look at how it operates, you reach the year end and you create this calculation of the rolling 3-year average, and then you take assets that are sitting in the account and you're paying them to future shareholders. As Justice Mansfield noted earlier, I think quite aptly, this is expressly a buyout of those shareholder interests. If you compare the plan to the shareholder agreement, there is no instance in which you can be a current shareholder and a recipient of plan payments. It's only available to shareholders. While your potential access to various funds vests over time, and in some instances instantaneously, they are all subject to various restrictive covenants. I'd note that section 6.1 of the plan incorporates a non-compete agreement that voids in its entirety a shareholder's receipts under this plan should it take a position with a competing accounting firm. These are characteristics that make this plan much similar to just a buyout of a shareholder interest, which is a non-exempt asset, as opposed to a retirement account.
Don't those facts also, at least to some extent, indicate that this is compensation to be provided in lieu of wages when you're no longer employed, right? I mean, all of these events really trigger around somebody's former status as a shareholder, and they forfeit those rights if they obtain competing employment. So we assume that they're not gainfully employed in a career that they've had for a long period of time. There are age triggers, there are disability triggers. It seems like this plan, in effect, is designed for somebody who's reaching retirement age and who's no longer a shareholder of the firm, and whose opportunity for compensation is explicitly restricted by the comp plan.
Well, I think
that true?
There's a couple of things that are implicated there. Again, going back to all of the decisions that are finding exempt assets, they focus primarily on the existence of some sort of contribution either by the employee or the employer. And I would disagree that the existence of a restrictive covenant makes this akin to an annuity, a pension, or another similar retirement plan, because it restricts an individual's ability to find other gainful employment. That characteristic is absent from any of the plans that we find exempt in any of the cases. I think this line of questioning also implicates the court's standard of review. I know Mr. Wandro disagrees, but I think the court is going to be bound by the district court's finding of facts because of the manner in which this case was ultimately brought to this court's docket. There's really three things that are implicated here. The first is the statutory scheme for which a debtor is supposed to assert their exemption claims. That's Iowa Code 642.15, which explicitly states that to assert an exemption, a debtor is supposed to file a pleading with the court, the district court, and if issue is joined, then that issue is supposed to be tried to the court. That application of that statute was discussed and applied by the district court, ultimately finding it did control in this case, and that was not appealed and is not part of this appeal. I also think Mr. McGowan conceded that the court's made factual findings as a court sitting as a trier of fact without a jury when it filed its 1.904 motion. As this court has previously recognized in the Meyer v. Senecott decision, a 1.904 motion is only available if a party is seeking reconsideration of facts found by a court sitting without a jury. So the simple fact of filing that motion is an acknowledgement that the district court was sitting as a fact finder and that its factual findings are to be subscribed.
Mr. Mather, isn't the only thing that's being reviewed is the written plan? There wasn't any testimony taken, right?
There was no testimony, Your Honor, but that is only because the debtor made the choice not to do so.
I know, but if all we're doing is reviewing paper, we can review it as capably as the district court did, right?
In most cases, I would agree, but in this one, because of the manner in which which exemption claims are alleged, and the manner in which this case made it to the court's docket, I think the district court's factual findings are entitled to some deference. And one of the reasons for that is because the appeal itself necessarily relies on that 1.904 motion. It creates an interesting choice for Mr. McGowan if we look at the history of this case before it reached this court. The district court issued its decision on October 30th, 2019. Under Iowa statute, a party has 30 days to file an appeal. 30 days would then have been November 29th of 2019. The deadline to appeal can be extended if you file a 1.904 motion. It's then extended to 30 days after the decision on that motion. The motion was ultimately resolved by the district court on November 29th, which would have been the 30th day. This appeal wasn't then filed until December 2nd. So it creates a choice. If the 1.904 motion was proper, the appeal is timely, but then this necessarily is a case where the district court sat as a fact finder without a jury, and then the district court's factual findings are entitled to some deference. If the 904...
we changed the rule a couple of years ago. We said on the 1.904 motion, we're not going to worry about whether it's proper or not. You get one bite at it, and that extends the appeal deadline, whether it's proper or not.
And regardless of that, I think the plan is fairly clear. There are a number of plan provisions here which support a finding that this is not an exempt asset. Starting at the top, section 1.1 of the plan does not identify this plan as a retirement asset, but as an incentive to shareholders to promote the growth, profitability, and long-term success of the firm. As previously noted, section 2.1 and 2.2 establish beyond a doubt that there's no contributions to a plan. There's no accounts that are set aside, but this is simply a mechanism used to pay current assets to former shareholders.
Heather, this is Justice Oxley. So you keep going back to there's no actual contributions to a separate plan, and the idea that this is only paper. So what is your response to Mr. Wandro's example of IPERS, for example? Someone who has an IPERS account is not exempt?
In the same sense, there is a balance that is created, and I apologize, I'm not fully up to speed on the intricacies of those types of accounts, so it's difficult for me to respond directly. But as the district court found explicitly by looking at the plain language of the statute, there is no set aside. This simply is just a running account balance that may be used to pay firm assets to a former shareholder at some point in time. And there's a couple of important restrictions I'd like to note just before closing here. One of which was the restrictive covenants previously noted in section 6.1 and 6.2. Another is section 1.5 that puts a cap on annual contributions. So regardless of what any account balance is, there is a finite limit on how much money may be paid in any one year based on how well the firm did that year. So even if a former shareholder would have been entitled to a certain amount of funds, if the firm can't meet that obligation, it doesn't have to pay that obligation. That really is a huge distinguishing factor between typical retirement accounts. And the last piece I'd like to note is this afternoon, Mr. Wandro made the argument, I believe for the first time, that this is really akin to a pension. But if that's the case, that seems to be in direct conflict with section 7.5 of the agreement, which seems to explicitly state that any money paid under this plan should not be considered or taken into consideration as compensation when determining the amounts of contributions among various other retirement accounts, including explicitly listing pension plans. So there seems to be a disconnect between an argument that this is a pension plan and the explicit language of the plan agreement.
Chief, can I ask one more question?
Yes.
Yes, go ahead.
We're
Sorry.
over time. Thank you. Mr. Mather, what relevance, if any, is it that this is a 409A plan regulated by the Internal Revenue Code for deferred compensation?
I think it's an interesting fact to note. I don't think it's dispositive of the issue. Again, if we look at the Eilbert decision, it lays out a number of different factors that need to be considered, and they have been adjusted and applied in different ways by different courts. But ultimately, the key component that differentiates exempt assets from non-exempt assets is the express purpose that it's really intended for retirement as opposed to a buyout of a shareholder status. And second, that there are contributions to the plan by somebody. That's expressly discussed in the Rousey decision and focused on in that decision and becomes a critically important part of the analysis. So if we look at the plain language of the plan, the history of this case, and the district court's factual findings, regardless of whatever test the court ultimately adopts or applies to this plan, I believe it is clear the district court was correct in finding that this plan is not an exempt account and therefore is subject to Commerce Bank's garnishments. Thank you very much.
Thank you, Mr. Mather. And Mr. Wandro, I'm sure you would like to reply. We can't hear you, Mr. Wandro. You get to start over.
I got to push the button. I was so excited
okay.
to get going.
You're just lucky. You're just lucky I told you. Thank you very much.
Thank you. Maybe I'd be better off if you didn't hear what I had to say. Actually, Judge, I want to make sure that the court knows that Iowa has opted out of the federal exemptions that you find under the bankruptcy code. Now, what makes this case difficult is it's mostly bankruptcy courts that have had to deal with this issue. But again, it's bankruptcy courts that are federal creatures, there's no doubt about it, but they are interpreting Iowa law. And this court has not had a chance to weigh in on what Iowa law is. And I would say to you folks is that it's this court that has the final say. Now, the Supreme Court and the federal scheme can deal all they want with federal laws, bankruptcy laws or whatever that have to deal with pension issues. But it's this court that's interpreting Iowa law. And go ahead.
If I might, section 7.5 of the agreement was referenced, and this is the section that says exclusion from qualifying compensation. And there's a reference in there that says any benefit earned or received by a plan participant pursuant to this plan constitutes special deferred incentive compensation, and then goes on to say, and shall not be taken into consideration as compensation. And then that's what references the pension, profit sharing, 401k. What are we to make of that?
What I would suggest to you is again, whatever this plan is doing, and I have a definite idea of what it's doing, isn't going to affect any other kind of plan that might be out there. But again, Judge, I want to bring it back to looking at the economic reality or Justice, the economic reality of what this program is doing. And again, it's whether it's on paper, whether it was actually money going back and forth, the thing is that it was done over a 20-year period. And it was done according to a plan that is now paying him out just as if it were any other kind of pension. And I think the thing that confuses people is this plan deals with owners, not an employer and a subordinate employee, but owners. And so when Mr. Mather is saying there's no contribution by other people, of course there are. It's all the efforts that the other owners are putting into this program that allow it to be funded, allow it to be profitable, and allow it to be paid out. And it's paid out to people only by certain events. And that fits squarely within what a pension does. And I think what Mr. Mather is doing is trying to fly spec this thing and make it into something that is not. The thing is, it's deferred compensation for whatever. It's paid over time, and it's paid by triggering events, and it has to deal with, in Mr. McGowan's situation, his age. 67, he reaches age, he gets his money.
Counsel, should we be interpreting this exemption narrowly or liberally?
Liberally. This court, I mean, that's an essential part of our jurisprudence, is that that this court, by virtue of what it has said for time immemorial, that in these kinds of these statutes are to be construed liberally in favor of the debtor. So if we're close, it's that presumption that's going to tip us in favor of the debtor.
Counsel, would you respond to the non-compete argument that Mr. Mather made?
I don't think it changes a thing. I don't think it changes a thing whatsoever. You can have other things in a compensation plan, but it doesn't take away from the essential elements of it that go to what it is, and that is a deferred compensation plan that works just like a pension. It's money that's going to be available to Mr. McGowan when he can't make money or as much money as he was before. And it's not unfettered. He can't grab it anytime that he wants. And it's on account of his age. And so I don't worry about those things because I don't think it takes away from the essential nature of what this plan is.
And Counsel, I think both sides agree the standard of review is for correction of errors at law. Are you on the wrong side of some really factual findings, or are we simply interpreting the words of this plan?
It's the words of the plan and it's the statute. It's interpretation, it's finding the meaning of this plan and the legal effect of it, which is construction, and interpretation of a statute. Now, the stuff that you have in here, the only facts, and the district court made a record of it, and these are uncontroverted facts, is Mr. McGowan's over the age of 67, and this plan's been in effect for over 25 years, and he's been contributing to it. There's no other facts. We're asking you to rule based on the paper that's in front of you. And therefore, Justice Mansfield's right. We don't have to get into deference on factual determinations that you would find in a trial, whether it's in equity or a jury trial.
Thank you, Mr. Wandro. I think the questions are done at this juncture, and the case of Commerce Bank versus McGowan is hereby submitted, as well as the third case not for oral argument, Great America versus Rodanova Medical Care, is also hereby submitted. Bailiff, would you please adjourn us?
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.